Hello, law students. This is Mrs. Politsky, and I have your notes for Chapter 1, Section 1, Laws in the Legal System. And there's a little section of notes here that you're going to have to find maybe a little space to write them on because I don't have it within your organizer here. So bear with me, and I'll kind of warn you when we get to that part of the notes. So let's begin. We're going to talk a little bit about kind of where our legal system and laws come from. And some of this is to kind of think back into the past. And there's a couple little images here. One is of a man named Hammurabi. Hammurabi was the king of the Babylonians. He was a Chaldean. And he is probably most noted for coming up with a code of law. And his code of law probably was made famous by sayings such as an eye for an eye and a tooth for a tooth. But really what Hammurabi did is he didn't really write laws, but what he did is he gathered them together and codified them, which was one of the first times that we had ever seen this done. And his laws probably would be interpreted as being pretty harsh, but yet at the same time, it allowed for some consistency as far as how people were going to be dealt with. The other man that you see here to the right is King Henry II. He was a feudal king of England, but he was also made famous for the fact that he went about setting up kind of a judicial system, and we're going to hear a little bit more about that as we go along. So let's start by talking a little bit about the stages of growth in laws, kind of the evolution of things, and it really starts kind of at the basics here. When people have been wronged, a lot of times people want to take revenge for the wrongs that have been done to them. And hence, they want to, make sure that somebody's getting their dues, so to speak, kind of the eye for an eye, tooth for a tooth kind of deal. Another way that this kind of has grown is the fact that you might have a leader that comes to power through force, and hence they want to punish those people who were once in power. You could have a situation where courts were formed. Part of this was to provide maybe a unbiased opinion of how to deal with people and their issues. And along with that, you have central authority figures. And that could be like a government in general intervening with some kind of action that's taking place. So all these events kind of lead to the establishment of laws at some point in time. So we're going to talk about common versus positive law. And common law, which you're going to hear a little bit more about as we go along here, these are laws that are based on current standards or customs. In other words, this is how a problem has been dealt with. And so we're going to continue to deal with a problem based on that example. It's used by judges to settle disputes and really is kind of the foundation of the British legal system. The other is what we call positive law, and kind of in a very simplistic way of explaining it, or at least your book explaining it, it basically says that these are laws dictated from a central political authority. In other words, a law that is dictated from above. And I want to break this down, and so you're going to need a little extra space here to write down these items here. But positive law, or sometimes known as lex posita, actually comes from a guy named St. Thomas Aquinas. He wrote about this, and he basically stated that this is law by the will of those who enact it or those who made it. And there's really four parts of positive law. The first is the divine positive law. This is God's law. And obviously, Aquinas probably had a lot to say about this, but, this is the stuff that is the will of God. You could talk about things like 10 Commandments or Jesus's commandments as being part of this. The other is natural law. This is recognized by reason alone and without the aid of revelation. This is the kind of stuff that maybe guys like Thomas Jefferson were thinking about as he was writing up the Declaration of Independence. This idea that, man has certain rights, certain unalienable rights, that's part of that. The third is positive law of independent states. And I think this is what probably a lot of us hear about when we hear about politics today. This is the supreme power in the state. In other words, man-made positive law. These are laws that are written by our governmental bodies. So it could be, anything from the local ordinances that come from your city governments all the way up to laws that are basically written and eventually enacted by our U.S. government. And the final is the law of nations. This regulates independent states' interactions with each other. And in a way, I think about this maybe in terms of like the United Nations. We hear a lot today about things like human rights and human right violations. This idea that there's maybe a just way to treat one another and how people should expect to be treated around the world. To me, it's a little harder to regulate and enact, but it's a kind of a code that we want to aspire to. All these are examples of positive law. Okay, so going back to your organizer, what are the origins of the U.S. legal system? We have English common law, which was started by the feudal kings, still in existence in England today. King Henry II, who you saw an image of earlier before, back in 1150, he established what is known as the King's Court. And this was a way to improve his legal system. And what the King's Court basically did was, it was basically Henry II picking some of his trusted nobles to become judges. And these judges would listen to the complaints of other landowners. And what they would do together is they would come to some kind of decision on each case. And hence that becomes the King's Court. And so the King Court could order wrongdoers to pay with money or goods. As it kind of evolves after Henry II, it might be known as the King's Bench or the Queen's Bench, which we still have yet to this day. Equity. This would be an alternative to common law. And you might see things like precedents. These are courts that use prior cases to guide deciding similar cases. You hear a lot about that in the American legal system. You might hear about equity, just basic fairness, how we want to be treated. And then finally, an injunction, which is kind of an order that comes from our courts that prohibits some kind of activity from being done. So it might stop maybe a dangerous act from being performed or the production of some kind of item that might be harmful to people who use it or the environment. And that is something that is commonly used throughout the United States. So what is the origin of the U.S. legal system? First, it comes from the Roman civil law. And depending on where you want to start, you could talk about it from maybe Emperor Justinian I, and the fact that, he kind of, codified some of this, but really it is the basic framework of law. Terms that you might hear that kind of have a Latin ring to it, like stare decisis, or talking about edicts or litigation, really all have their foundation here. Things that we take for granted here in the United States, like checks and balances and separation of powers, or even like identifying a plaintiff or a defendant in a court case, all comes from Roman civil law. And hence, it is probably one of the biggest influences on our U.S. legal system to this day. The other is the English common law system. And part of that is because of the fact that many of our former colonies that would eventually become states were using it. And hence it becomes kind of the setup here. We talk a lot about precedents and using those examples that have come from the courts. That actually still has a certain, tone in the American legal system yet to this day. All right. Thank you very much.